morning, Madam Registrar. Can you hear me?
I can. Thank you very much.
I'll just begin by reading a short statement, if that's okay.
Thank you.
This hearing is in the matter CFI 70 of 2020 before the Registrar Nour Hineidi and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the Registry in Dubai on the Registrar's instructions. The claimant is appearing as a litigant in person. The defendants are represented by El Tamimi & Co. Lead counsel is Patrick Dilemma.
Thank you very much. Mr. Dillon Malone, given that it's your client's application, perhaps you can walk us through your submissions. But what I'd like to do from the outset is, Ms. Khiat, how do you pronounce your surname, please?
It's Khiat.
Khiat. Okay, thank you very much. Now, can I ask you to mute your microphone when you're not speaking so that the sound quality is better?
Right.
Thank you. And I just want to ask you, do you know what this hearing is about today?
It's about the application to strike out from the case.
Correct. And do you know what implications that might have on your case?
It might finish the case immediately.
Correct. So if I grant the order for strikeout, which is what the defendants are seeking, it means that your case will not progress to trial and that the case will be closed.
Yes, I know.
If I, however, hand down an order that the immediate judgment application is not granted, it means that the case will progress to trial, which means you go to case management. Mr. Dillon Malone, I've read the skeleton, which has been very helpful, and the two witness statements of Mr. Zaman, which have been filed in support of the application. So I thank you very much for drafting those. There was several e-bundles on the system, which were quite difficult to navigate, but I'll let you walk me through your e-bundle and then we can kind of go through Ms. Khiat's submissions after you make yours. Thank you.
Thank you, Registrar. I'm grateful. The bundle that we will be referring to and relying on is the bundle called Defendants Hearing Bundle. And I hope you will see that. And it has a number of subfolders numbered A to F. I cannot hear you now. Registrar, are you muted?
I am. I apologize. Thank you. I could. Yes. Thank you very much.
Very good. Perhaps if I might just address a number of preliminary issues first, Registrar, to try and put some structure on it. I don't propose to start the general opening in circumstances where you've read the witness statements and the pleadings. And so I think I can go straight to some of the technical aspects. Just in terms of the contract of employment, if I can give you some page references. The contract of employment is at page 20 to 25 of this bundle. And on page 25 itself, there is a jurisdiction and governing law clause. Now, there is no issue on jurisdiction in this case, even though the jurisdiction and governing law clause refers to UAE law and competent or concerned UAE adjudicatory bodies. The first defendant is a DIFC entity, and Ms. Khiat was employed within the DIFC, and there's no issue on jurisdiction. So that's number one. The second point is on limitation. In circumstances where this case began life in the Small Claims Tribunal and was commenced on the 8th of December 2019, which was about almost exactly a month after the termination of Ms. Khiat, then no issue arises under the ordinary 6-month limitation period for employment claims under Part 9 of the DIFC employment law. So just to get those first issues out of the way, no issue on jurisdiction, no issue on limitation. You'll see from the claim form, the amended claim form, which is at pages 4 to 5 or 3 to 5, that the case as pleaded, insofar as it's pleaded, is said to arise under DIFC employment law and to be based upon whistleblower protection and victimization. And as we have reflected in our submissions, I can no longer see you, Registrar, but I presume you are still hearing me.
I can, Mr. Dillon Malone. The problem is I'm making notes on my computer. If you prefer that I have my camera on, I'm very happy to do so.
It's entirely a matter. No. It's just I wanted to be sure you could hear me.
I can definitely hear you. Ms. Khiat, do you mind if my camera is off while I make notes? Ms. Khiat?
Very good.
No, sorry, I don't mind.
Thank you very much. I'll make notes, and when I speak or when I think it might be helpful for you to see me, I'll switch it back on. Please carry on, Mr. Dillon Malone. I apologise. Thank you.
Thank you. Thank you very much. The point that I make is that those whistleblower protection and victimization are the issue before you in this case, and those correspond to Article 60 of the DIFC employment law, which is on page 183 of the bundle. I won't open it now, but you'll see Part 9 of the DIFC employment law is on pages 182 to 185, and within that, Article 60 is on page 183. That is the victimization element, and then the whistleblower element corresponds to Article 64 of the operating law, which you'll find on page 235 of the bundle. Now, Registrar, you will have probably seen from the material that in addition to those complaints as pleaded, there is in the material that has been placed before you by the claimant a complaint that my client, the first defendant, has held on to a degree certificate, and it's alleged that this was held on to as a vengeful act by my client. The explanation that I'll bring you to in the evidence is that that is not the case, that the degree in question does not appear to be there. And we said, Mr. Zaman has said in his second witness statement that even if in some way we're mistaken, and that if that degree is to turn up at the bottom of somebody's drawer or is found at a later date, it doesn't obviously give rise to any claim against the first defendant. And honestly, that position has been described in evidence. So our position, as you know, the defendant's position, is that even if everything that Ms. Khiat says is accepted as true, there is no case for victimization because none of the complaints which she makes relate to a protected act or arise from that within the meaning of Article 60 of the employment law. And secondly, that even if everything that Ms. Khiat says is true about the so-called fabrication of that was in some way victimized by having raised a complaint that was in fact investigated, even if it is true that that my client, which of course is strongly denied, that my client in some way penalized her and dismissed her because she raised this complaint. It's not in fact a complaint that comes within the whistleblowing provisions of the operating law. I'll come to that. There are difficulties, of course, with that complaint. No law is actually pointed to. But fundamentally on the facts, Registrar, as we'll come to, and as you will have seen, the suggestion that Ms. Khiat makes is that there was some manipulation of these salary benefits and certificates for the purposes of deceiving the visa system applicable to another employee's mother. And you'll see from the actual material in the evidence, which I'll bring you to, and the explanation of Mr. Zaman, which is particularly at paragraphs 10 to 15 of his first witness statement. And you'll find that on pages 13 to 14 of the bundle. And from the report of my client, dated the 4th of November 2019, which you'll find at pages 46 to 47 of the bundle, that in fact the true position is entirely innocent. There's a perfectly sensible explanation by Mr. Zaman about how these certificates issued. And in any event, the threshold for the relevant visa qualification was met by the earlier salary as well as by the later salary after the change. So none of that adds up as such. Now, to the extent that Ms. Khiat says that she apprehends that we were in some way seeking to deceive the system, this court has before it the totality of evidence relating to Ms. Khiat's conduct and her alarming and quite reckless and disruptive conduct that led to her dismissal for gross misconduct. And it has before it that pattern of behavior which this court is entitled to take into account on this application as well. And
Mr. Dillon Malone, I'm sorry to interrupt you. I just want to flesh out this report in some more detail. So was this report prepared by your client? The report that appears on pages, I think it's 46 and 47 of the bundle.
Yes.
It was a report that was prepared by your client. Okay.
Yes.
And where it says...
The compliance manager report. The compliance that I reported the fraud to. She made that, I think.
Sorry, I'll just ask Mr. Dillon Malone the question, and then if you've got anything to add, I'll give you a chance to speak up. Mr. Dillon Malone, could you just confirm to me who prepared this report? The one dated the 4th of November, 2019.
Yes. Why don't I just bring you to that? It's on pages 46 to 47.
Yes, please. Thank you.
Sorry, I'm unaccompanied today, so if you could please bear with me.
Take your time.
Okay. You'll see it starts on page 46. It's an incident report dated the 4th of November. And you'll see from Mr. Zaman's statement that, in fact, the complaint had originally been made to a third party and then was investigated internally. Mr. Zaman's explanation of that background is on pages 10 to 15, or sorry, paragraphs 10 to 15 at pages 13 to 14. And there was a report to compliance on the 3rd of November 2019. And the report the investigation was carried out by management, and I believe was Mr. Zaman himself was involved in this report. In terms of the authorship, I have to go to the, it's not indicated on the letter, as on the report as we've established, but in the witness statement.
Yeah, he refers to it at paragraph 14, I think, of his first witness statement.
Yeah. In 2019, the company was outsourcing its risk management to Capital Advantage. On the 3rd of November, Ms. Khiat made a false report to Capital Advantage to the effect that the company had submitted an incorrect salary letter in support of Ms. Hijazi's mother's visa application, which the company had started processing in October 19. I believe that Ms. Khiat had made this allegation being unaware of the revised offer letter and consequential increase in Ms. Hijazi's salary. In any event, as a result of this report, the company undertook an investigation and produced an incident report. And it's not indicated here who the author of the report is.
Mm-hmm. Because I guess what I'm trying to flesh out is the whistleblowing component of Ms. Khiat's claim, which has not been articulated in any detail in her particulars or anything else for that matter. So I want to flesh out in my mind how that may give rise to a whistleblowing complaint, if any. Ms. Khiat, and I'm sorry to interrupt at this stage, Mr. Dilla Malone, but given that we've raised the question of this report, we may as well just discuss it at this stage. So, Ms. Khiat, are you saying that your whistleblowing complaint is because you raised this issue with the third party? Is that what you're saying?
No, I first raised this issue with the management itself.
Right.
But then they were like threatening me and menacing me and whatever. So when I didn't find any other way, I raised this issue to the compliance manager at the time.
Okay, so I just want you to walk me through, in your words, in very simple, in a story type format, what this situation entailed. So you were responsible, as I understand, for dealing with visas, perhaps?
Yes,
at the company?
was the one. Yes, I did all the visas for all the stuff, like at the time, right?
Okay.
So
right.
Then came this girl. She was new, it's okay. But also I had access to all the HR files. So I was the one filing her contract. So
okay.
I know how much she was getting exactly.
Filing her contract where? In the internal systems?
In the internal system and in the HR cabinet. You know, in every company there's some HR cabinet.
Right. Okay.
Right?
Yes.
I was responsible of that also because we didn't have a sitting HR manager for maybe 1 year.
Okay.
So if the for example, if the COO asked me for a contract, he will tell me, "Oh, Reem, can you go to the contract of Fahad, for example, open the drawer and get me his contract?" So I was aware of how much these people were getting. Right? Okay, so she wanted to sponsor her mom's visa.
Mm-hmm.
Right? I called the AFC. They said sponsoring the mothers for a girl is not possible. But she was insisting again because she didn't want to go do it outside. She said outside it will take long, and she was complaining like that. Mm-hmm. So she went to Iftikar because he came new at that time. He was very new. He came new, and she went to Iftikar, and Iftikar said, "Okay, wherever you want, we'll do it." But then, as you can see, I put it in a bundle. There is a notification from the AFC that asks if the sponsor's salary is like 25,000 dirhams. You saw that, right? I put it on the.
Can you take me to it, Ms. Khiat?
All right, 1 minute. It's on the proof of fraud.
Okay, proof of fraud. Let's have a look.
Alright, can I just a minute so I can like hand it?
Take your time.
Yes, proof of fraud and timeline of events.
Right. So which bundle is that? Because there's a number of bundles that I can see on the system, and they all say denial of all reasons of termination. So they could be duplicates of each other. Let's open
I think
up one
it's
of
in
them.
the denial. It's in the denial. Just a second. In denial of all the
Okay.
reasons of terminations, and there is.
Okay.
Normally I put it alone, but I don't. Just I put it there. All right, just a second. Sorry. Ah, yes, I have it. Okay.
So what page is this on?
All right, just a second. Got it. It's on page 7.
Page 7. Okay.
Yes, yes, you can
Which
see
is a
the system.
screenshot.
Yes, you can see the system is asking if Riwa's salary is about 25. And actually,
Okay.
because this was there, they decided to lie about her salary. Even if it was 2,000, they decided, okay, it's just 2,000. We'll make her a salary certificate based on that if the IFC asks, or I will upload it on the system so it will be a support.
Okay.
All right. After that, like, I did what they wanted, to be honest. After that, came on page 9, I received a notification from the IFC saying like, okay. And before that, I aware Iftikhar. I said, Iftikhar, in this application, there is her bank statement. The IFC can check, even if it's 2,000, it's dangerous. But this guy didn't care about me at all.
Okay.
And then on Wednesday, October 30, page 9 on the same bundle, I received this application, bring her bank statement. That's where I went to the Iftikhar itself.
Okay.
But then Iftikhar was like, no, don't worry, we'll make her, if the IFC ask, we'll just say she was like just taken a small loan from the company, and we are deducting from her account. Like,
okay.
She's taking 25 and we deducting because she took a loan. And by the way, this is what they told the police, and this is the only document I cannot get until now. This is why I need help from the court or somewhere, because I need this document. Because in the police, they said she's taken 25 and there is a loan, which make her have 3 contracts until now.
What police? I don't know anything about the police. There was police involved?
Yes, because these guys were menacing me. I took the salary certificate to the police to just be sure they will not take it anywhere. And because also there was a law in the AFC that said if there is a crime, because I didn't know how to handle this, they said if there was a crime, I have to report it to police and to DFSA, which I did.
Right, so what happened when you reported it to DFSA?
DFSA, because I didn't know about the DFC codes, DFSA said because it's a contract, employment contract, you have to go to DFC codes. And that's how I came to DFC codes.
Right, so, okay.
So after this, I complained to the police. I just felt sick. I took 3 days. I took 3 days of leave, and I put them here in page 15. So I complained to the police on the 31st. I complained to the how to call it, to the manager.
31st of October? 31st of October?
31st of October, police, and just after 1st or 2nd, I complained to compliance manager. I took then a sick leave of 3 days, on 6th November, I come back to the office to get like a warning email about my attendance. Like the events are like, so like I complained on 31st, I complained to the office, to the compliance manager on the 2nd. I was sick 2nd, 3 and 5. On 6th, I received a warning letter for attendance. On 7th, I was dismissed from the office without taking any action. Yes.
Okay, so I'll let Mr. Gillian Malone carry on with the rest of his submissions now that I've understood the situation in more detail. Thank you, Ms. Khiat. Mr. Gillian Malone, please carry on.
Thank you, Registrar. If I could refer you to page, we're back on the report, the incident report, page 46. The finding of the company on inquiry into this complaint was that the salary of the requirement from the Dubai authorities was 20,000 or a monthly pay of 19,000 dirhams plus a 2-bedroom accommodation to sponsor visa requirements. And there's a reference to a link to the government website for that purpose. So if we go back then to pages 41 to 42 of the bundle, same bundle, you'll see Ms. Hijazi's original benefits schedule, which was a basic salary of 17,000 and another allowance of 5,000. And then if we go flick forward to, that's in the second and third row of that table. And then onwards to page 43, you'll see the revised offer was 18,500 plus $6,000. And
excuse me, Dr. Patrick, I had to add something about three was second.
I'm sorry,
Ms. Khiat. Sorry, Mr. Gillian Malone, what was it that you just said?
It's a matter for you, Registrar, whether you wish to allow Ms. Khiat to speak now.
Ms. Khiat, I'd prefer to hear from Mr. Gillian Malone without interruption, because when you spoke, he let you speak. So if you just make a note, please, on a notepad, I will give you your time to voice exactly what you want to say. Okay? Thank you, Mr. Gillian Malone. Please continue.
So insofar as this question was raised as something which suggested wrongdoing within the company, it was investigated by the company. It was found on inquiry that there was no breach of any government regulation, and they refer to the contemporaneous requirement of that. And their matters rested. But I think it's important to go back to the evidence. Of course, this is not the only thing that was happening at this time. And if I could refer you, please, to Mr. Zaman's first witness statement at paragraphs 4 onwards. So on page 12, you have the description. I won't open it all because you've read it, but you have the description of this sustained pattern of erratic, volatile, and obstructive behavior on the part of Ms. Khiat. These included quite alarming behaviors, which were the diversion of the chairman's telephone to her own telephone, unauthorized access to the chairman's office, all part of an increasingly alarming conduct. And if you can, I won't open the record of her attendances, but it is clear when one looks at it that at pages 28 to 35 of this bundle, the red writing indicates late or missing hours, late days or missing hours. The red highlight indicates absent days. And if you take out the weekends and non-working days, and if you take in the additional absences that might have been also highlighted red, but in fact the sort of system is in some way fooled because a single entry is entered for that day. But you'll see in the right-hand column the absences. That this was an employee that was not performing her function, and that was indeed in a situation of gross misconduct. And that's obviously not a matter before you, but it is, when one looks at the complaint of A, victimization, or B, whistleblowing, you have to ask the question, what was the real reason for Ms. Khiat's dismissal? And the real reason is clear on the evidence. It's absolutely clear that there was a pattern of behavior which was unacceptable and which led to her dismissal. And
Mr. Dillon Malone, sorry to interrupt you and interject. I mean, it seems to me that the events that arose towards the end of October, beginning of November, might be the straw that kind of broke the camel's back. And correct me if I'm wrong. I have seen obviously the attendance logs which were exhibited to Mr. Zaman's witness statements. But I haven't seen anything about, and of course, as we said, this is not the question before me now. What I'm trying to figure out is whether there's any merit to this whistleblowing claim. And that's perhaps where you can assist me. Because it seems that, okay, yes, she was late to work and she was late on many occasions, and the attendance logs were given for, I think, April, May, June, if I'm not wrong. So nothing kind of towards the end of her period at the company, which was October, November. But there's nothing else about, reports which kind of record her inappropriate and unprofessional behavior, or reports which record the careless behavior or anything like that. Again, I'm just relying on the witness statement of Mr. Zaman, and it looks like he had joined the company kind of a little bit late in the piece. So the only reason I'm asking these questions is to, like I said, find out whether there's any life in the whistleblowing claim. Because if there is any life in the whistleblowing claim, yes, you're correct that at the moment the evidence that the claimant has provided is sparse. There's not much of it. And it could simply be the case that her papers are not procedurally in order. But that's something that can be easily remedied. So if there is any credibility to the whistleblowing claim that the claimant has talked about, then that's kind of a reason for me to say, well, we probably need to progress to a full-on trial and figure out if there's anything that the court has missed. So maybe you can walk me through that and assist me.
Yes. Well, I think that you have the sworn evidence of Mr. Zaman, and that is the evidence before you. Mr. Zaman explains why Ms. Khiat was dismissed, and the reasons for her dismissal are in the termination notice itself. There is a contemporaneous record of that. Perhaps I could start with the termination notice, which is on page 36 36 of the bundle.
Thank you. And Mr. Dillon Malone, just a quick point. I'm looking at a case where Etherton, Justice Etherton in AC Warden's Son and Caitlin 5 Limited said that, I mean, my role at the moment is not to take everything in a witness statement on face value. So there will be some analysis and there will be some kind of deeper digging into the truth, essentially. So I'll let you walk me through, but where you can back it up with evidence rather than just, you know,
yes,
that would be most
certainly
helpful.
Yes, I think I'm not. You understand? I mean, we have made clear that the question of looking behind a witness statement in the case of an immediate judgment application is for the purposes of dealing with issues of credibility, which the court is entitled to take account of, and the assessment of the totality of the evidence. And here you have a company with a rogue employee who's out of control and creating difficulty at all sorts of levels. The company has good reasons to dismiss and does dismiss on those grounds. Those grounds are reflected in the termination notice, and they have been explained by Mr. Iftikhar in his statement. In the middle of that, one has a bogus and contrived complaint that is raised by Ms. Khiat for the purpose, for reasons of her own, which is duly investigated at a time when matters are getting really out of hand. And I don't think it is correct, and it's my respectfully submit that the evidence doesn't support the complaint being a straw on the camel's back. I say, on the contrary, it is not relevant. It was not relevant at the time, and it was not an issue that led to her dismissal. It was not was not even taken into account, because the real reasons are the reasons that are set out in the evidence. And if I could refer to page 36, you'll see in the termination notice, and I won't labor it, but effectively, that's been terminated with immediate effect due to gross misconduct, unauthorized access to office on off days, unauthorized access to telephone system of the chairman, inappropriate behavior, unauthorized absenteeism, and late attendance. Those are the reasons for her dismissal. And they are set out and evident to you, Registrar, in the evidence of her attendances. And I don't think it's fair to characterize her late attendances and absenteeism as some lateness. When one interrogates those records, they demonstrate that this was an employee who simply turned up when it suited her. And the conduct that is described then in the witness statement is one of increasingly erratic behavior, a rogue employee. And the complaint was duly investigated, it's recorded, and the conclusion that is reached is that there's nothing in it. And going behind that, obviously it's not a matter for you to well, it could be a matter for you to, at least to the extent that you say, well, that's not enough. I need to inquire, or the court may need to inquire later. But it's relevant to your assessment of whether this complaint can go anywhere following a trial. That the underlying conclusion, the conclusion of the company is based on the objective requirement of the visa system at the time. And the explanation, I think it is important that I bring you to the explanation, because I do want it to be not lost from sight. At paragraphs 10 to 15 of Mr. Khiat's first statement, I'll leave the second statement. I think I do rely, Registrar, on paragraphs 8 to 17 of Mr. Zaman's second witness statement, because though it is clear in my respectful submission on that evidence, which is the sworn evidence before you, that this was serious misconduct. This was gross, and those are the reasons. The attendance record, the unauthorized attendance and use of company equipment, unauthorized access to and diverting calls from the chairman's office to her own telephone, and extremely alarming behaviour. But
Mr. Dillon Malone, I appreciate everything you're saying, but that still doesn't really answer my question. I mean, the lateness or the attendance records are logged until the 30th of June 2019. She was terminated in the beginning of November, so there's nothing for July, August, September, October, for example. And there's still no reports. I mean, yes, for those months, certainly I wouldn't have been surprised if she was terminated early July, because certainly the attendance records, which I can and will probably take on face value on the basis that they're automated and they're system generated, speak for themselves. So yes, I can see that her start time would have been, for example, 8:30, finish time would have been 5:30, and there's a large number of days where there was just simply a no-show based on these records. But the fact of the matter is she wasn't terminated in July, she was terminated in November, and that's where the question mark is for me. So perhaps you could assist me with that. And again, the unauthorized attendances at the chairman's office, are there any incident reports? Is there anything that could assist your client's case on the fact that the termination was by reason of gross misconduct? Obviously, that's what you say, but yes.
Well, it is the case, and it's not disputed by Ms. Khiat. It's not actually contested at all. Ms. Khiat accepts that she accessed the chairman's office. She accepts that she diverted his telephone. She takes issue with the automatic recording system. But that's not the matter before you. The evidence before you, it's clear that she was dismissed on certain grounds. And those grounds are not really contested in the sense that Ms. Khiat says that the real reason for her dismissal was something else. But she doesn't actually dispute the underlying facts that led to her dismissal, apart from the late attendance, apart from something on the late attendances. And the question, of course, if this court requires up-to-date records in the interests of the overriding objective and to avoiding what we say would be a complete waste of this court's time, we will provide that evidence, and we'll be happy to do so. I'm sure they exist, and we could provide those, and if the court wished to adjourn to allow that evidence to be put in, we'll be happy to do so. Obviously, the evidential position, the evidential deficit in this case is very much on the other side, and if time has been taken for that purpose to allow us to put in our additional evidence, perhaps Ms. Khiat can rectify the absence of any sworn evidence on her side as well. But I dispute and respectfully submit that the evidence that is before you of those late attendants up to the date on which they are exhibited before you, it's to be inferred from that there was no lateness up to the time of Ms. Khiat's actual dismissal. But obviously, I take the point that you prefer to see the complete record. And on this application, yes.
Yes, Mr. Dillon Malone. It's not that I would prefer to see the complete record. It's the fact that I'm trying to piece together this mystery of a case where, on the face of it, yes, it does look like Miss Khiat was the fact that she was dismissed, that is completely justified. But there's still a question mark for me that I have an obligation to investigate. It's a red flag. I'm wondering why very suddenly in November, after she drew light to this issue surrounding this, perhaps a compliance related situation, I'm wondering why it was only at that stage that she was dismissed. I am not in any way, shape or form saying that there was no right for the company to dismiss her because as you said, the facts speak for themselves, at least based on the attendance records. But it's just the period in which she was dismissed, that's the question mark for me. And if there are any merit, any, as you say in your submissions, what's the word? Just bear with me, please. I feel that she may have a realistic chance at this whistleblowing complaint rather than fanciful, as opposed to fanciful, if this was to progress to trial. And right now I'm relying on the company who has provided a lot of evidence and who's represented by a very good firm to show me why, given that you have filed the application, to show me why why the claim is actually fanciful and not a realistic one. So I'm, in a way, the onus is on you, Mr. Dillon Malone, to prove that this should not progress to trial. And at the moment, like I said, there is question marks in the evidence and there's things that I'm not quite satisfied of. I may be satisfied of these questions as we continue on today, but at the moment there are question marks. So if, to the extent you can, yeah.
Okay. Well, I'm going to go back to the critical sequence of evidence and the report, if I may. And I do
yes.
It's going back to that. So on page 13 of the hearing bundle, I'm starting at paragraph 10. In early 2019, the company was in discussions with Ms. Hijazi in relation to her application for the position of office manager to the chairman. An offer letter was issued on the 28th of January 19, offering her a monthly salary of $23,064. Ms. Hijazi had an elderly mother and asked the company if it would be willing to provide her mother with medical insurance. Since the company's medical insurance policy only extended to an employee's spouse and children under the age of 18 years, this was not possible. However, in order to accommodate Ms. Hijazi's request, we took the view that her salary could be increased so as to cover the medical insurance premiums that would be payable for her mother. As a result, the offer to Ms. Hijazi was revised, and a revised offer letter dated 12th of February 19 was issued to her. The terms of the revised letter were that Ms. Hijazi would be paid $25,063 effective from the successful completion of her performance review in October 2019. Now you see that the offer letter was dated the 12th of February. Until that date, Ms. Hijazi would be paid $23,000. However, on completion of her performance review, her increased salary of $25,000 would be backdated to her start date. Consistent with the revised letter, I had confirmation from management in October or November 19. Ms. Hijazi had passed her performance review and therefore her salary had increased to $25,000. I was approached by Ms. Hijazi in early November to request that I issue a new salary certificate for her revised salary and acted on that request. And I've exhibited the salary certificate that correctly records that salary. In 2009, the company was outsourcing its risk management. I think that should be 2000.
Thank you, Mr. Dillon Malone. You may carry on. I think you were taking us to...
Just paragraph 14. I'll just finish these two paragraphs.
I know that you've read them, but I do believe they merit rereading. It's in the middle of paragraph 14, Registrar. Thank you for your patience. I believe that Ms. Khiat had made the allegation being unaware of the revised offer letter and consequential increase in Ms. Hijazi's salary. In any event, as a result of this report, the company undertook an investigation and produced an incident report. As recorded in the report, it was that Ms. Hijazi had taken the relevant salary certificate that was the subject of the report. Given that I'm the person in the company responsible for issuing salary letters, I can confirm that any salary letters issued by me would have been consistent with Ms. Khiat's salary at the relevant time, namely 23,000 prior to November 19 and 25,000 on and after the 1st of November 19. As can be seen in the conclusion of the incident report, it was found that there was no breach of the visa regime. However, it seems that Ms. Khiat has persisted with her false allegation by way of this claim without providing any details of the alleged inaccuracy in the salary certificate and without providing a copy of the salary certificate. Now, forgetting about the copy, that report, that then should be read in combination with the report itself, which is at pages 46 to 47. And here, there is a record which shows that the company quite properly took on board this complaint that had been raised with the compliance function, and that they duly looked into it to see was there anything untoward. And the company concluded that the visa regime wasn't breached. It says an expatriate employee can sponsor his parents for a year's stay by paying a deposit as a guarantee for each parent, as stipulated by the respective immigration department. And then down below, according to the website of the government, to buy a minimum salary of 20,000 or a monthly pay of 19,000 plus a 2-bedroom accommodation. So in this case, there was no conclusion on page 47 is that there is no breach of the visa regime, as the salary of the sponsor is above the required threshold of 20,000 dirhams per month. There was no rationalization for fraud on company level. The DIFC-GS returned the application, as DIFC-GS does not deal with parent sponsorships, but GDRFA instead. No further review of the documents on service center level. As the hard copy of the salary letter is missing with Khiat, along with other documents, disciplinary warning must be issued and taken with HR. Compliance records the data protection breach in the register. Code of conduct training to be organized. Also circulate the email on the incident reporting for investigation to compliance.
And Mr. Dillon Malone, my question here is the disciplinary warning, is that a warning issued to Ms. Khiat?
Yes, I believe so. Yes.
Okay, because that was one of the other questions that I had. And the code of conduct training to be organized, was that also code of conduct training to be organized with Ms. Khiat to remind her of her code of conduct obligations to the company?
I believe so, yes.
Okay. All right, that's very helpful.
So
because it wasn't clear. It wasn't clear from this. Yes, it wasn't clear from this report who the disciplinary warning was to be issued against. Whether it was to be issued against the HR person for not keeping proper records of things, whether the code of conduct training was to be done internally. That's what's not very clear. But given that you've now clarified that it's a warning against or issued against Ms. Khiat and training to be organised for Ms. Khiat on code of conduct, that makes sense to me. Thank you.
Thank you. And in that regard, Registrar, if I might refer you also just above the conclusion to the action points, which I think confirm that. that this was a matter of concern to the company, and that there was on the point 3 of the actions, there's access user, remove Khiat until further notice. What I do wish to emphasize is that the letter of termination and the grounds that were relied on are the grounds that exclude any reference to this quite properly. The totality of the evidence before you indicates a company acting wholly responsibly, wholly correctly, and in accordance with procedure in investigating a complaint that was made, and that coming to a rational conclusion on that, setting that totally aside in relation to the other gross misconduct that was operative and accumulating at this time. And I do again rely on the second witness statement of Mr. Zaman, of which I've already just referred to, but just to reiterate, from paragraph 8 to 17, plus his earlier witness statement at paragraphs 4 to 9, plus the evidence in the first exhibit, including the termination letter. Of course, Ms. Khiat was paid all of her entitlements, notwithstanding that she was dismissed for gross misconduct, and notwithstanding the provisions in the contract. At pages 22 to 23 of the bundle, you'll see that, strictly speaking, the company was under no obligation to pay her those full entitlements and her notice requirement, but nonetheless it did so. So the company, the first defendant, acted entirely correctly, entirely properly in dealing with a rogue employee, and very carefully, notwithstanding all of that misconduct, very carefully investigated and correctly dealt with the complaint in its proper compliance context. And that record is before you. That issue which is raised, and the complaint that Ms. Khiat made, was set aside and formed no part of her actual dismissal. Now, of course, in a trial of that issue, if it were to go ahead, the court might seek to test whether my client is lying about that, and whether the real reasons were in fact retaliatory and vengeful, and that they were penalized. There was penalization. But that in order for Ms. Khiat to get past today, in my respectful submission, it's not enough to raise an allegation, a bare allegation, which is unsupported and which is contradicted by the actual record. It's also a complaint which makes no sense, because the initial complaint that she raised was without substance, in the sense that there was no breach of the visa regime. It appears that her allegation was based on a mistaken view of the facts at the time. That was investigated, and it was found to be mistaken. The connection to a disciplinary aspect that arising from the retention by her of a salary certificate, which she ought not to have, is a discrete and distinct disciplinary consequence of that inquiry. And again, it had no connection with the wider grounds of misconduct that were the reasons for her actual dismissal. And in terms of the first defendant, the second defendant, on my application today, there's no evidence at all and no reason at all why the second defendant should be part of these proceedings. None has been suggested. So in my respectful submission, the application must succeed on the second, in relation to the second defendant, equally for the reasons set out in the skeleton. And briefly, Mr. Khalid al-Mulhim has no case to answer on any wrongdoing in law, either as pleaded or otherwise, on even taking Ms. Khiat's allegations on their face. So, in my respectful submission, the second and third defendants' application for a strikeout or alternatively for immediate judgment must succeed, in my respectful submission. And for all the reasons I've given, obviously I will be given the confusion and the evidential position of the claimant's case. I'd like an opportunity to obviously reply to anything that is now said. Obviously, we do rely on the fact that there is an evidential burden on Ms. Khiat. The fact that she's not represented is a factor that obviously you will, and no doubt are taking duly into account, as is wholly correct. But nonetheless, she does have a burden, and she has a burden to raise a case that is sufficient for this international commercial court to justify devoting resources and time to an inquiry into a matter that, in our respectful submission, there is no reason to inquire further into, and would be a waste of this court's time. So those are my submissions for the moment.
That's very helpful. Thank you very much, Mr. Gillan Malone. Ms. Khiat, it's your turn now to walk me through your submissions on why this case ought to proceed to trial and why immediate judgment should not be granted. Mr. Gillan Malone has raised a number of things which you will need to respond to. You can do this in your own words. Obviously, Mr. Gillan Malone is a silk, so I do appreciate it might be difficult for you to respond to each and every point that he has mentioned, but please try your best. And if I've got questions, I will interrupt you to ask those questions.
No worries. First of all, I have no problem because I have all the evidence and it's very clear what happened. Okay. So first of all, we start with the Riwa second contract, right? The false contract.
Which false contract, sorry?
Because she has two contracts, right? And they have uploaded them.
Right. So can you take me through these in the bundle, please?
It's from 0001, fraud, proofs, and timeline of events, right?
1 second, please, while I just find that. Okay. Yes.
So on page 4, I highlighted Iftikhar Ali Zaman like in a first witness. He said like she was taken 23 prior to November 2019 and 25 after November 2019. And now on page 8, there is a salary certificate. This is the salary certificate that I took to the police. The salary certificate is dated on 14th October 2019.
Just bear with me. So this is on page 14.
No, on page 8.
Page 8.
Yes. So Iftikhar was saying that her salary became 25 after November. And the problem with is like they don't remember, so they say anything and like they lost their mind, like they don't remember the timeline of the event. And also her second contract, her first contract is on page 5. This is her original contract. She doesn't have any contract. This is her only contract. The other one is on page 11. On page 11 is the second contract, right? Or the second, the agreement is dated on 12th February, but there is no proof they made it on 12th February. Plus, I have a comment. There was no, Iftikhar was in Saudi in February, and Talal was in Saudi in February. So and Riwa only came one time before her employment. The second time she came was on her first day. So she came first in January, and then she came on March. February, she was never in office. So how did she receive this offer letter? Via email? If she received it via email, where is the email? This is my point. Because no Iftikhar, no HR manager, there was no Naveed, there's no one in February, there was no one. I was the only one in the office with the other stuff. So logically, who gave her this contract to sign? If no one was in Al Khair, Dubai, in the FC office, who gave her this contract to sign? And for more evidence, you can ask for Iftikhar passport, Talal passport. You will see there was no entry to Dubai in that date. They were not here. If they were here, where is the email that you sent her for that?
I guess the question I have at this stage, Ms. Khiat, is what are the implications of a company kind of, I guess, you know, I understand the implications of someone not telling the truth and providing incorrect information for the purposes of securing a visa. But what are the real implications of the company, you know, doing this in this way? So let's just say that everything you're saying is correct, and for example,
they did it, and they were like ashamed to to do it right. So just they put the blame on me, rather than accepting their mistakes, yani. So they put the blame on me.
But what are the implications to the company if all you're saying is correct? Would the company lose its license? Would the company be deregistered with the DFSA? Would the company be held criminally liable?
To be honest, yes. I don't care what will happen to them. What most important to me is this thing will never happen again, because these people are dangerous. These people are dangerous. And you don't know what they did to my colleagues after I left. I mean, they literally like terrorizing them to not talk to me. They told them to block me.
Right. Okay. So I just want you to walk
also me through. They send me like, these people are crazy. They send me a letter to ask me for a lifetime contract. I'm not a trader. I just was an admin. How can you ask me for a lifetime contract? Where is that? It's like you make me a slave for you? What? I don't understand.
Okay, so I want you to just walk me through your complaint and exactly what you want from this company. What do you want from them? What are you claiming? What's the relief that you want from the court to grant in your favor? And then we can talk about your evidence.
I want to be granted damages for
for what?
For like damages like the whistleblower protection, and damages for all the pain that I've been through. Like I'm working, like now I have work, and I have to pursue this case for one year and a half. They terminate me. I was like looking for a job for 3 months. 3 months I was like not like getting a salary for something that I didn't do, for doing something wrong. This is like, you know, when you do something right and you get blamed and punished for it, my integrity is gone. Like, and now I will think, no, before reporting a fraud or something, oh no, something will happen to me. You know, so the vision of the right thing, the good and the bad, they messed with it a little bit with me. Because now before doing something right, I will ask myself 2 times, Like, why? No one will believe me. They will create a story. Like this offer, the second offer letter, they don't have any proof that they made it on 12th February. They have the stamp and they have the typing. They can type and 10 offer letters like that.
Right. So have you read through the whistleblowing law?
I have read a little bit, but to be honest, like,
which is
as I'm not a lawyer.
Yes, so it's a DRC operating law. So you've got to make you've got to be proving your claims under the operating law. So,
I have proved it.
Yep.
I think I have proved it. These people terminate me like the timeline of events, and they have, this girl has 2 contracts. The second contract, they don't have any proof that made it at that time. And if you go to the police, you will find the 3rd contract.
Ms. Khiat, there is lots of evidence that Mr. Dylan Malone has provided to indicate that you were absent from work on many occasions, that you were late to work.
I provided that I was never, no, Iftikhar said I was absent due to my absenteeism on 2019. I have proved by pictures that I was there in the office. They just marked me absent just like that. They marked me absent in the holidays. They marked me absent on sick leaves. They marked me absent everywhere, like it was random. But when I checked it, I checked that I was not absent in the whole 2019. There was only 2 dates I couldn't verify. 2 dates. I was not absent. I could not verify these 2 dates. And Iftikhar was saying it was due to my absenteeism pattern. Where?
Right.
Where?
So being late to work. So they've provided a log, and there's no reason for me at this stage to
being
sorry. Let me finish, Ms. Khiat. Let me finish my sentence, please. There is no reason for me not to believe the attendance records that have been provided by the defendants, because it appears to me that they're system generated. And I can see what you've said, that you've provided screenshots of Snapchat, uploads which you say you were in the office on that particular day. But it seems to me that you were late for work on several occasions, etc. Do you, and that Mr. Dylan Malone said that there was certain evidence which you did not deny about, issues that you've had with coming to work on, using the office on days that you're not working, unauthorized
why would I be blamed?
calls.
From where did I get the access? They gave me the access. And I want to point a very important thing. They say I had access to the office on Friday. On that same day, there were strangers in the office. Why didn't you ask them about that? They were like the chairman's daughter and her tutor. And the reason why I went to office, because the security was calling the driver, Suhaib, and Suhaib was calling me because I lived next to the office. So Suhaib was telling me, go there because the security was calling him. Like, two complete strangers. Like, who are you? And this girl, she said, I'm the tutor of the chairman's daughter. They were using the meeting room. And I am terminated because I used the printer or the scanner. And the access, they gave me the access. Why should I be blamed for the HR mistakes? How did I access the office? And why are these people there?
But Ms. Khiat, I mean, the difficulty that I have is this.
Yes.
You need to prove to the court that
Yes.
you have a realistic chance at this if this was to go to trial,
I
and not
think
a fanciful chance. Just let me finish. I'm just trying to explain to you, and I'm explaining these things to you so you can assist me in making my decision.
Yes.
But basically, if this case was to continue, and to put things into perspective for you, at the moment you have no evidence. There's no witness statements that have been provided by any of your ex-colleagues at the company. There's no real evidence about, your performance. And on the contrary, there's no real evidence from the defendants on your bad performance except for the attendance records. So at the moment, there's a lack of evidence, to be clear, on both sides, but more so on your side. more so on your side. And if this case was to continue and to go to trial,
I have
then
evidence on the
let me finish,
essays.
please. Let me finish my sentence. If this case was to proceed to trial, okay, and you lose the case, which at this stage you might do because you don't have any evidence on your side, you are liable to pay the costs of the defendants in defending these proceedings. And these costs will substantially outweigh the claim, just speaking from experience. So if this case was to continue, then you could be liable for maybe a few $100,000, if not more, dirhams worth of costs, which I would suggest that that is a large sum of money. If this case was to discontinue today on the basis that I would hand down immediate judgment in favour of the defendants, then the costs would be limited. At this stage, I'm inclined to say that they have more evidence than you, and it's looking like it might be the case that there is no clear evidence on your part that you were victimized, and I say that within the meaning of the employment law, as Mr. Dylan Malone has walked us through. So if you can try and assist me on what evidence you might be bringing, what sort of things you can assist the court with to prove your claim, that would be most helpful.
All right, I already have provided evidence because the Iftikhar was saying I was absent. So I already provided evidence that what he was saying is wrong. That's the first thing. The second thing, the contracts and the salary certificate that I provided dated on the 14th October. The third thing is like they have no warning letter was issued, no nothing. I was even getting promoted, you know, because my performance was that good.
Do you have evidence of the promotion?
I have emails sent like from the data protection, like sent from emails from my side that I was like sending emails to the interviews receptionist, and also in the SCT, Talal admitted, the HR manager admitted that I was going to be promoted.
Okay, do you have,
like,
now that aside, because I'm not sure if the SCT hearings are recorded, but that aside, do you have any written evidence of that?
No, I just have emails I sent from my email that for the interviewing the receptionist.
Who would be taking your job?
Yeah, he would be taking my.
Okay, can you tell me where these emails are?
It's with them. I just have like a screenshot.
Okay, that's fine. Can you show me the screenshot, please?
Don't have it now. Like, hold on. I tried to get it. Sorry, it might take a little bit of time because I have to look at it from in my emails.
That's fine. Please take your time.
All right.
Registrar, might I just explain, my colleague, Mr. Basiso, received instructions from my client who has forwarded the up-to-date records to the end of October 2019. And
that's very helpful.
Been uploaded, with your permission, at section D, other documents of the defendant's bundle, at pages 140A to 140H. So it's document number 22 in the defendant's bundle, and that information is now there. If I might respectfully ask that they be taken into account as part of the record.
Thank you very much, Mr. Gillan-Malone. And while while we're there, is it possible to get, if any, records of, reports made to suggest that Ms. Khiat was at any stage, not dealing with things in the proper way or yelling at other colleagues, etc.? Is there any records of that? And if not, that's fine, but that would be helpful.
I will take instructions, and my understanding is that we've put before the court correctly that the relevant record. But if I'm mistaken in that, I do apologise. I will take instructions to make sure that we're not missing anything of relevance. And I think Mr. Basiso is listening, and my other colleague, Ms. Marshall, is in touch with him.
Excellent. Thank you very much, Mr. Gillan-Malone. I'll take a look at those in a second. And Mr. Gillan-Malone, while we're here, what does your client say about this promotion?
It's the first I've heard of it.
Okay, thank you. Ms. Khiat, have you found?
I didn't find it yet, but if you want, I can send it to you throughout the day.
Okay.
Right.
Sorry, Mr. Gillan-Malone. Okay. I had interrupted you. Did you say something, Mr. Gillan-Malone?
Oh, obviously we will likewise take instructions, I believe. But it's certainly not something that featured in my instructions on the end.
Thank you.
I've just received an instruction confirming that there is, quote, no truth in the promotion claim. That is my client's position. We can put that in evidence if needs be.
Okay.
But your client said that to the judge, in front of the judge.
Right, Ms. Khiat. Can you carry on, please?
Okay. Then also I have uploaded some documents for unpaid, translation that I was not working for. They made me do something. They promised me to pay me, and they didn't pay me until now. And because I opened a case, they completely denied. Because I opened the case, they completely denied the translation work I did. But with the data protection process I did with them, I have a proof, and they admitted what they completely denied in the SCT. So these people, they are not reliable. They say something, and then they say something again.
Sorry, Registrar, that again, I have to say, is not part of the complaint that we've come to meet. That again is a matter that just doesn't arise on the pleadings. It's not part of this case. I don't have any instruction.
I agree, Mr. Dillon Malone. Mr. Khiat, we've got to stick to what you have set out in your particulars of claim, because that's what counsel has instructions to deal with from his client.
So the translation thing, I will never get paid for it, even with the court?
I mean, that ought to have been in your particulars. You may, if this application continues, you may apply to amend. This is very
important. They refused to pay me something because I opened a court case. And I upload the proof, like total proof.
Okay, but it's got to be in your particulars of claim, because at the moment I can't see that is something that contributes to the whistleblowing. I can see it as contributing to the overall, conflict between yourself and the defendants.
Also, for me, like going to the chairman's room, as I explained very well that I was doing the verification process because I have access to the employees' HR forms. And given that Iftikhar was not there for like 1 year, how did the employees get their loans and credit cards? Because I was there. They was calling the number that were online, which was my number. The only case that they called Khalid al-Mulhim number is because they find, a dewa bill that has his number there. And I don't understand why would I be terminated for this. And Iftikhar, who has caused another case, there was another case open because they didn't pay Fahd Ishaq employee wages. The case is CFI 17120.
Yes, but we've
I got terminated because I was doing my job, and this guy caused complete case against the company and is not there, and it doesn't make sense. They say like me going to the office on Friday, which they give me access to, is like gross misconduct, but this guy caused almost one colleague of my colleagues to lose her life because he didn't renew the insurance on time, and he's still there. Also,
Ms. Khiat, we've got to look at the case in question. So I think what the defendants are saying is it's not, we shouldn't take in isolation the fact that you went into the office on a weekend unauthorized, for example, if that was the case. It was not
unauthorized, it was okay because we didn't have any, I was going to office before, but they were paranoid this time because they knew after, they were paranoid. I was going to office before. Sometimes I forgot my charger, sometimes I forgot my bag, sometimes I forgot my wallet. I go to bring it and they know, but they never questioned it. The only time they questioned it was that Friday, because that Friday, after that, they knew I opened the case against them. So they were paranoid. So I can steal something, but I didn't do anything because I know there was cameras. I'm not stupid. Also, the fact that the chairman's daughter was there, how can you, there is no common sense. You are terminated me because I went there and some stranger was there. It's okay. Where is the common sense here?
Ms. Khiat, let's focus on the question at hand, okay? The question at hand is that you say there's whistleblower allegations. There's no evidence really to support the whistleblowing allegations at this stage.
Because I'm just denying the reasons because they don't make sense. The only reason they terminated me for was that compliance report, that fraud. Because they cannot terminate me for entering the office on Friday and they allowing a stranger to enter the office.
But as I said, it wasn't that situation in isolation. So there was a few other things that were described in that letter of termination. Okay.
Yes, they was also saying absence, but I was never absent.
Now, of relevance is these records of you not coming to work on time. And the case I've had a look
they
through.
Didn't have any problem about that because
Ms. Khiat, please let me finish my sentence. Please do not speak over me, because when you speak over me, I can't hear you. I'm having a look at the records provided by the defendants. They've properly provided them. They've provided them at pages 140A to 140H at Part D of their bundle, and they are records which indicate that even after June 2018, actually I think it's from 140G, so from the 1st of July 2019 until the 31st of October, there seems to be a lot of absence in that period.
No, I was never absent. I was never absent. I just like
or
was
at least
not punching. That's it. I was not punching. That's it. Like sometimes I forgot to punch. That's it.
right.
But I was never like. See, I was never blamed for it because it was okay. Because I didn't complain about the fraud at that time. They were okay with everything. And because also I was like a good person, like I'm a good worker, I'm not that awful. And if you want to compare, bring someone as like attendance and you will see no one cares about that punching machine. Bring director's attendance and you will see this guy will never punch. And it's okay, they didn't terminate him.
Okay, Ms. Khiat,
If
I need
you want to be fair, bring another employee's attendance and you will see.
Right, so you can do this. You can make these types of applications under the DIFC court rules. But I need you to provide evidence of your claim. At the moment, there is no evidence of your whistleblowing claim at all. Okay, there is no evidence of that, and there is no evidence of the fact that you were victimized or that you were mistreated. Okay, there is no evidence of that.
Because I was terminated right after I complained, and that the compliance report explains it. And also, all the reasons like do not make sense. Like there was never there was a warning, for example, never. How come there was never any kind of warning? Also, the fact that the fraud, I almost proved it. I only need like the police report. That's it. And you will see that was a clear fraud.
What police report? What did the police conclude after you went to them with the report?
The police said they brought a contract that states she's taken 25, but she has taken a loan with the company. That's what the police said. So it's completely different from these two offer letters. Even the second offer letter is a proof of fraud because they don't have any, they were not there. Where is the email they sent her? So I proved the fraud. I proved it.
Ms. Khiat, to prove a fraud,
there was no warning, yes.
To prove fraud or for there to be a whistleblowing, a live or a credible whistleblowing complaint, what would usually happen is a complaint would be made to a regulatory entity, for example, the DFSA or whatever the case might be. It would be investigated.
I made a complaint to the DFSA.
Right, and what was the outcome of that complaint?
They sent me to you guys.
Right, but typically what would happen with a entity that's dealing with money, for example, is the DFSA would conduct its own investigations. Okay, so this is solely, this is an employment case. This is not a whistleblowing case in my view.
But to be honest, I don't know which case it is, but I know I was not terminated for anything rather than this thing, the fraud thing. And I know there was a fraud. So is it like fair that I get terminated this way for something good I did?
Ms. Khiat, for there to be a fraud, there has to be repercussions that the company would have faced in the event the fraud was made out. And this is why
there is, but I feel like there is no one helping me to get out this fraud because this second offer letter, they have no proof. They can make 10 offer letters. They have the stamp. They have everything. They can make 10 offer letters. But I want to ask you something. If there is like a change in a contract, how come the ministry is not aware?
This is not a question at the moment for me to look into because this is not something that's been pleaded and this is not something that was raised in evidence beforehand. I don't know if the ministry. I don't know if the ministry has been informed. I don't know the answer to this question.
Because the second contract was made in November 2019.
Right. So not
in February.
Let me explain something to you. You might have a situation, okay, I'm going to put this in very simple terms.
Yes.
You would have a situation where, for example, you would go to the hospital to get a surgery, okay,
Yes.
and something would be done wrong.
Yes.
For example, the doctor may have administered a medication that you should not be taking,
Yes.
right?
Yes.
And okay, there's, for example, let's just say that the doctor has come forward and said, acknowledge that he's given you something that you shouldn't have taken.
Mm-hmm.
Okay, but then you decide that you want to make a deal out of it. So you go and you might raise a complaint with the regulatory authority that looks after doctors and medical professionals.
Mm.
Okay, and they say, okay, great, thank you very much for letting us know, but what's the damage done? Now, in this situation, the difference is that the company hasn't come forward and said that there's a fraud, but there has to be a proof of some damage. If you have not sustained damage by reason of let me finish. If the company, okay, is not liable to its regulator on this issue, then this cannot be a whistleblowing complaint. All right, so the doctor, for example, if the medical board says that the doctor is not negligent, then the doctor cannot be liable for a complaint that you bring to sue him in court for his medical negligence. Does that make sense? Because the person policing the doctor would be the medical board, would be the medical regulatory authority. Okay, and they might say, okay, even if the doctor comes and says, no, I did not administer the wrong medication, and you say, no, you did, because look, you've administered it. First you said you were going to give me this medication, but instead you gave me this medication, and the doctor says, and I'll put it again in very simple terms, and the doctor denies it and says, well, actually, I didn't give you the wrong medication, and I stand by that. And you go to the regulatory board and you say there was negligence and he needs to now lose his license. And the medical board comes back to you and says, no, we don't find that there's a negligence, but you can take this up in court if you want. And you're bringing it to court now, and the doctor says, well, actually, she did not comply with the certain instructions that I gave her before coming into hospital. She didn't do X, Y, and Z. He's got evidence of that, and this is why I've given her this medication. And you have nothing to say to that. This is exactly that kind of situation. So at this stage, okay, the company, you made a complaint to the DFSA. There's no ongoing investigations happening at the moment. It is very, and I'm telling you this from just a normal everyday perspective, even if the company did decide that you were no longer a good fit for them, they have to go through certain employment protocols under the employment law to get rid of you. But that's not something that you've pleaded. You've pleaded whistleblower protection. Okay? Now, if you have gone off to the police to make a complaint about the company, just if I was to go and make a complaint about my employer, for example, that would cause a great deal of tension and a great deal of friction. Okay, so why would they want me to come into work, and how would they trust me if I've gone off to the police and made a complaint about them? Now, I understand your point of view. Yes, I understand your point of view. Let me just finish. I understand your point of view in that you thought it was the right thing to do. Okay, and if you had pleaded that this was wrongful termination, that's a very different kettle of fish, but that's not what you have pleaded. You have pleaded whistleblower protection. Okay, so now you can walk me through what you want to say.
Okay, first of all, this guy Iftikhar said like Riwa's salary was like effectively, and Patrick, correct me if I'm wrong, he said Riwa's salary was effectively 25 after 1st November 2019, right?
Sorry?
Iftikhar, in his witness statement, clearly said that Riwa's salary was 25 after November 2019, right, Patrick?
Mr. Dillon Malone, I think the claimant's asking a question.
Oh, sorry, Judge, excuse me. I think, yes, it's in it's in his first witness statement.
Yes, but okay. How does he explain the 14th October 2019 salary certificate then?
It's also in the report.
It's also in the report, but he said that the salary came effective.
Excuse me, sorry, I was asked a question by the registrar. It's also in the primary evidence is in the certificates at pages I think 43 to 46, and in the report.
Which evidence was that, Mr. Gillen Malone?
They are the certificates. The benefit schedule at pages 41 to 42 for the first period prior to November 19, and then the pages 43 to 44, the revised offer. We referred to those earlier, and you'll see that the additions of the salaries add up to sums that are over 25,000, over 20,000.
After which date? After November 2019.
The explanation is in the first witness statement of Mr. Zaman at paragraphs 12 to 13. And the date is the performance review was in October 19.
But
so
her salary coming effectively 25 on November 2019. That was Iftikhar said.
Registrar, I don't really wish to get into a dialogue with Ms. Khiat. The evidence is at paragraphs 12 and 13 on page 13 of our bundle. And at paragraph 15 of the same witness statement on page 14. On and after the 1st of November 2019, that's at paragraph 15 on page 14. The date is the 1st of November. So on and after the 1st of November 19, the salary changed.
Okay, then how does he explain the salary certificate of 14th October that I have?
Ms. Khiat, you address the court, please, and not Mr. Dylan Malone.
Sorry. All right, then I have now proof of the fraud, right? Something wrong happened, and that wrong thing I reported to the authorities. After reporting the wrong things they did, and this is the proof, I got terminated. Not because of my performance, not because of coming to work at 9:30, not because going to office on Friday, for that thing.
Ms. Khiat, I think the word fraud is used a little bit loosely here. Like I said, you've got to prove, with fraud, you've got to prove that there was an intention to deceive, and that intention to deceive was for a financial gain, for example, or for some other gain. In this situation, I just can't see it, quite frankly. I just can't see it. Assisting an employee with visa requirements for her mother, in my view, is not a fraud. It may have, perhaps the way that it was done was not entirely correct. And yes, the company does acknowledge that. So perhaps to an extent there is some merit in what you say. It wasn't done in the entirely correct way. But to call it a fraud with an intention to deceive an entity or for financial gain or any other gain is not something that you have proven.
See, this salary certificate was going to the government. The government. Is it right to provide something that is not correct to government entity? This makes me think like maybe I did something wrong or reported something right.
I understand what you're saying.
I'm not saying with my integrity.
Yes, I understand what you're saying, but there is something very different when you say that. Now, look, I'm not saying that what happened was proper, but I'm not saying that it goes so far as to be fraudulent behavior on the part of the company.
I know it's not that big. I know.
Yes, but so now what I would say is
Sorry.
Would you mind silencing your phone, please?
Hello.
Thank you. So what I'm saying now is that your contention in your particulars of claim, and let's go through it. Let me walk you through it, okay? So you provided a 2-page particulars of claim, and you've provided an amended claim form.
Mm.
And your brief details of claim is that you were terminated because of reporting a fraud that the HR manager did, and that Al Khair Capital has also unlawfully retained your original
Yes, they
bachelor's
returned
degree, right?
yes, they returned it.
Right. So in your amended claim form, you haven't stipulated whether this is a employment type complaint or whether it's a whistleblowing complaint. But then you'd go on later to say that this is a whistleblowing complaint. You do particularize it in that way.
What?
Okay, so there is no reference to the employment law, for example, to say that you were unlawfully terminated or anything like that.
I will explain why.
Okay, go ahead.
So when I went to the lawyers, I went several times to the lawyers, and I have this is the thing that they came with, like it's victimization and whistleblower. This is after I explained the story. This is what they told me to. Because I'm not like a lawyer, I don't know like exactly the terms, and I don't know exactly the law terms, and I don't know exactly how to put it in a law, draft. But I know exactly what happened, and I have proved it.
I understand, Ms. Khiat, but what I'm trying to say is when you come to a court, so let's, again, using that example that I gave you about the doctor, right?
Yes.
Let's just say that you decide later on that he wasn't negligent, but there was something else. So he was trying to, willfully hurt you. You can't go back to the medical board and change your complaint because you initially pleaded negligence, and now you're pleading, let's just say, I mean, this is really taking it to the extreme, but let's just say willful murder or something like that. And you say, oh, actually, I've changed my mind. This is what he was trying to do. The board would say to you, oh, we're really sorry, but there is no teeth to this. Now, if you came earlier and provided these two things as your kind of complaints, they kind of go against each other. So again, that's a really bad example. But all I'm trying to say is you cannot change the nature of your complaint now. And your complaint about the whistleblowing, I understand everything you're saying. Everything you're saying might have some light to it, some truth to it, some credibility to it. But what you've really got to prove in a whistleblowing complaint is that there was a intention to, there was something that the company was trying to do when you use the word fraud to gain, it's either a financial gain or some other gain that they are trying to kind of progress with in order to better and further themselves, and they're doing that illegally. And then you go off and you make a complaint to an entity which starts investigations, and by reason of that, you were then terminated from your position. Now, this is something we deal with. We've got one whistleblowing complaint here, and typically whistleblowing type, let me just finish, please. Whistleblowing type complaints usually in respect of insider trading transactions, white-collar crimes, things like that. So things where a company would be doing, or people within a company would be doing something to really further the company or themselves individually. In this situation, what you have, and I'm just saying this from a very common sense point of view, you've got a situation where a company may have said something on a salary certificate that wasn't quite truthful, and that's giving you the benefit of the doubt that this was the actual position, okay? And then you've gone off and you've made a complaint, but that complaint, I mean, that act that the company did to write certain things on a salary certificate, that is not giving the company any financial gain or anything like that. It was doing it to essentially help out another employee who was in hardship. Okay, and
But
that's
I
again,
have something else to add, if you permit.
just let me finish, please. Okay.
Yes.
So taking all of that into account, and the fact that you then went to the police, right, and the fact that there is these logs to say that you're late, and even if I was to accept that, yes, some people don't swipe in and out, some people do show up late to work, some people sometimes might swipe in and out, but they might do it later in the day, or whatever the case might be. The fact that, and this is what I was hoping Mr. Dylan Malone would assist me with, the fact that you went to the police and you made a complaint against your company, and it kind of put the company put your relationship with the company in tension.
I will explain
why. Okay,
yes.
But just let me finish, please. Just let me finish. That then resulted in termination, I think, on the 19th of November or thereabouts. But you were paid out certain entitlements, you were paid out certain things, and your complaint in any event wasn't that you were let go improperly or that there was any unlawful termination on the part of the company. Right, so now explain, but I'm telling you right now that at the moment...
Why did I go to the police and stuff? Because I didn't have, you have to put yourself in my position. Like, they were like forcing me to do it. I even went to Iftikar and said, listen, all right, withdraw me. I will withdraw this application and you do it. I don't want to take any risk for myself. But they didn't care about me. They were like, oh no, you have to do it. We give you an order. So what would I do? I will be in trouble with the government, or will I be in trouble with the company? There was like this was a hell of a situation. Like, what will I do? What will I do? Like, maybe if I submitted, maybe I would have been in trouble with the government because I was the one signing in the DAFC portal form.
I understand, Ms. Khiat, but that's still
I didn't have a choice. That's why I went, and as a last resort, I complained because I felt like awful. These people were forcing me. It's like no. Why didn't Iftikar do it, for example? No, they were forcing me. No, you do it. Who the hell are you to say no to the chairman and this kind of stuff? This is okay to happen.
Ms. Khiat, I understand. I
went there to work. I didn't go there to have like some people menacing me and put me on trouble with Dubai government. I'm not like I'm a normal human being. I don't want to be in trouble with the government.
I understand
because of someone's visa.
Right, let me finish. Let me speak, okay? I understand what you're saying, and it was a difficult position, right? But it still does not give rise to fraud. It does not give rise to whistleblower protection. This is what I'm saying. Okay.
What do you want me to do in that position? So should I just like go and let it go and like I lost, like, you know how much I lost money about this thing, and I lost 3 months without a job because of a good thing I did, like supposedly. Why would I be unemployed because someone is not following the rules? Why is that fair?
I understand, Ms. Khiat, but at the end of the day, you can't confuse tension and a cultural clash between, the company's culture and what you might be expecting from the company as an employee with
what I'd be expecting is them not forcing me to do this.
Right, but given that, and this is what I'm saying, given that there has been these attendance records and things like that, at the moment there is a lack of evidence.
If there is any fairness, compare my attendance to other people's attendance. That's it. That's it. If there is any fairness in this world, you compare my attendance to the others and you will see.
Okay, Mr. Dylan Malone, what are your thoughts?
Yes, thank you, Registrar. I have, I think, 4 points. The first one I think will really assist. If we could go to page 43, please, of the defendant's bundle, of our bundle. And this is the document which is signed and dated 12th of February 2019, and you'll see that the indication of the job offer condition on the 4th row down It says job offer condition. Do you see that?
No, we don't see.
Ms. Khiat, please open the bundle, the defendant's bundle at page
I thought
43.
he was like sharing it. Alright. Which bundle?
Page
Defendant's hearing
43.
bundle, page 43.
Which section? Sorry.
It's just page 43.
So it's under section B, page 43.
B 43.
Okay. Yes, and Mr. Dylan Malone is walking us through the revised offer between Ms. Hijazi and Al Khair Capital, and he's taking us to job offer condition, which is at row 4 of the table.
Thank you very much, Registrar. Do you see that?
Thank you. Yes, I can. Thank you. Ms. Khiat, please mute your microphone.
Thank you. It says the monthly salary of 25,063 dirham shall become effective only once you complete your performance review in October 2019. Until that time, you shall receive an amount of 23,063. Upon successful completion of your performance review, you will also be paid the difference of your salary from your joining at pro rata basis. So the suggestion that there is, because this document predated the 1st of November 2019, that it in some way misrecords the actual position in terms of the salary up until the 1st of November and then after the 1st of November is completely misconceived. And there's no wrongdoing. On our evidence, I respectfully submit that there isn't even anything untoward or not entirely correct in what are.
But Mr. Patrick, there was no one there to give her that letter to sign.
Ms. Khiat, please address the court.
Oh, sorry.
So it's an entirely, this whole complaint was entirely misconceived. It was based on a bogus assessment of some sort of bad faith manipulation of the record, when in fact, on its face, it perfectly correctly records the position. That's my first point. If I could refer to page 126 of the same bundle, you'll see again the suggestion that was made that Ms. Khiat says that she did have access, and because she was a person who carried out certain functions, that she was then, what's the difference, more or less, between doing that and accessing the chairman's office and diverting the telephone to her own phone. And look at, if I could refer please to section B, the claimant admits that she attended the company's office, etc. But then down to section C. I would like to reiterate at paragraph 15, I would like to reiterate that the claimant did not have authority to access the chairman's office and divert his calls to her telephone. It was also not within the claimant's duties to verify employee terms by way of incoming calls from our bank. This task is and was at the relevant time my duty as HR manager, or the duty of my predecessor in the same role, or more generally the duty of senior management. It is of note that the claimant gained access to the chairman's office through an office assistant, being fully aware that her personal access key would not grant her access to the chairman's office. It is all the more.
I have verified
Ms. Khiat, I will not repeat this. I cannot hear you when you speak over Mr. Dylan Malone. Okay? So please let him finish and I will give you an opportunity to speak and respond to his points afterwards, okay? Please mute your microphone for now. Thank you.
Thank you, Registrar. It is all the more suspicious and concerning that the relevant bank verification call was in respect of none other than the claimant's own employment terms. Now, the evidence of Mr. Zaman in his first witness statement and his second statement, in my respectful submission, is constrained and objective in accordance with the best practice of witness statements before this court. But when one looks at the termination notice and looks at his evidence, the the actual reasons for Ms. Khiat's dismissal are those that were recorded in the dismissal notice, and they included, which Ms. Khiat has not denied, unauthorized access to the chairman's office and diverting calls to her own phone. They included unauthorized intervention in communications between the company and the bank in relation to matters that were not part of her function, and against that overall background of erratic behavior, non-attendance. She was dismissed for gross misconduct. The third point is, I think I've probably already made it, which is that the allegation is an allegation of fraud, and you've anticipated, Registrar, of what I wish to say in large part about that. The suggestion being made by Ms. Khiat is that the document that is at page 43, because it relates to a contract or an agreement which is said to be in force from the 12th of February 2019 and is signed and dated by the employee in question and by the chairman, and with an expected joining date of the 10th of March, that this is in some way a fabricated document, a forgery that has been put forward to deceive the authorities. That, of course, is an unsupported allegation. It's a bare allegation, and as against that, one has the actual objective threshold which was required to be met at the time, which is the subject of the report, and the real evidence of the actual contractual position. And then when one combines that with the fourth row of the page 43 document, one sees that there isn't actually any deception. There's an actual accurate description of what Mr. Zaman describes, which is an entirely understandable employment sequence, which is that this particular employee was on a performance review, and that his salary would be increased subject to performance conditions on a performance review. And that's what happened. And it's all fully documented. So the complaint that was made that is misconceived, not only as to whether the threshold was being manipulated by this information, but also because it's based on a misconceived notion that what we were in fact reporting to the authorities was in some way inaccurate, that it didn't reflect the true position, but in fact it does. So as against that, the allegation of fraud or of wrongdoing by the company is sufficiently contradicted by the record and by the explanation and the evidence that we've given in my respectful submission, that it can comfortably be dismissed on this immediate judgment application, on this strikeout application. It can go nowhere. It's incapable of going nowhere. And my fourth point is an overarching point, and I think it is important that I say it for the purposes of the test, which is that I think there is a danger sometimes on these immediate judgment applications where, and I think, Registrar, you have been very careful to keep us focused on the legal case that is being made, or that has been advanced or raised. But there is a danger that we say, oh yes, there's a difference of fact here. There's a dispute as to the fact, and how can I possibly address that now. And what Mr. Zaman says in his witness statement, and I've reiterated it more by way of submission, which is that there may be strong disagreement between my client as employer and Ms. Khiat as a former employee on some of these matters. She has raised very, very serious matters. She's raising them now in this forum. But they're not material differences of fact, because they go nowhere. We strongly contest them, but they're immaterial to the victimization complaint that in any event can't stand, and to the whistleblowing complaint. It is entirely misconceived. I'd just add a fifth point, because I noted that you, Registrar, raised a legal issue, which I respectfully agree with, that these particular circumstances probably do not fall within Section 64, Article 64 of the operating law. But that legal issue, we don't need to rely on that, because as a matter of the totality of the evidence in our respectful submission, the threshold simply isn't met evidentially to bring Ms. Khiat within an Article 64 claim. But my clients do also rely on that legal argument, and if you're writing a reasoned judgment on this application, we do believe it is an issue which is appropriately addressed by you, which is that this is an employment. This arises in an employment context, and is a matter that hardly no law is identified which my client is alleged to have breached. The only evidence before you of any law, as required by Article 64, one of the matters that needs to be identified is the breach of a law. And the only evidence before you, and the burden is on Ms. Khiat in this regard, of any regulatory requirement, is that it's agreed between the parties that there is some requirement in order to qualify for a particular visa qualification, that there is a financial requirement. But the actual origin and basis of that requirement is not before the court. I don't believe that that's a defect for the purposes of your adjudication. I think you can decide this on the basis of, yes, the parties are agreed that there was a threshold. You have the evidence before you as to whether or not that threshold was at any time not satisfied, or whether there was any misleading information in relation to that to the authorities. And in those circumstances, we say that there is no triggering of any violation, any breach of any law. I think you, Registrar, have correctly asked the question: what would the consequences be for the company if there had been if there was truth in the idea that we were signaling to the authorities in October that this person's salary would increase on performance review above the threshold of 25. Now, leaving aside the fact that in fact the real threshold was 20, but the question being addressed was whether it was above 25. We say that there wasn't any misleading information in that, and that the consequences and that the type of that this factual circumstance does not actually trigger the application of the operating law at all. that's a legal issue which is subsidiary to our main submission, that on the evidence, including anything at all that may come out at a trial, this complaint was misconceived, entirely misconceived to begin with, and there's no prospect, no realistic prospect of Ms. Khiat succeeding on that, no matter what evidence might come to be put on the record in advance of a trial or at a trial. So I hope I haven't been too long and roundabout on that last point, but I think it is important to include that argument for the purposes of today, that there is at the very least a significant doubt as to whether this factual matrix could trigger the operating law at all. Subject to any questions you may have, those are our reply submissions.
Thank you, Mr. Gillan-Malone. Very helpful. Ms. Khiat, I'll let you respond, and then I'll give some directions. Thank you. You're on mute, Ms. Khiat.
All right, thank you. First of all, I want to say that for the verification process, I want you guys to see denial of reasons of terminations.
Yes, thank you. That's at page 81, Mr. Gillan-Malone, I think.
Yes. All right, and there is indexes 0002 and 0003. And I want you guys to go to 0003. You will see salary certificates.
1 second, please.
Let me know when you see it.
What page is this on, using the defendant's reference to the bundle?
I'm quite like, the defendant's reference is like very, I don't know which page is that.
I'm sorry to interrupt. I think Ms. Khiat is referring to her own bundle.
Yes, it's my own bundle. Is here in bundle number 2, denial of all the reasons of termination.
Okay, just give me a moment, please.
Yes.
Okay.
Okay, you open the index number 0003. Do you see it?
No, I'm just struggling with the numbering a little bit. Bear with me, please. I think we've got different numbering. Thank you, Mr. Gillan-Malone. Right.
You got it?
Yes.
Do you see it?
Yes, thank you.
So this is a salary certificate that I signed for Iftikar.
Okay.
In fact, I was doing verification for all, even for Iftikar, because there was no HR manager in the office. And in the documents before, I explained how the verification process happens and why the banks call my number and why am I authorized to. My previous manager, Michelle Ling, was making me do this because it was not that important to her because she has a lot of work. So I continued in this pattern, and that's how a lot of people in the office got their credit cards, loan cards. Even Iftikar got his auto loan with me verifying it. So how does he explain this? If I'm not the one doing verification, why does he lie about this? It's just to make a point, just to make me the one that I'm not doing verification. I don't understand. I was doing it, and he knows I did even verification for him. And this salary certificates proves it. If this was not on my function,
does that make? What point does that make?
The point that is Iftikhar is lying about the verification process. Two, because they say I entered the chairman's office, but the fact that I was entered there is like just to complete the verification. I did the verification for several employees. Iftikhar was one of them, and explain the salary certificate. If my role in the company was like just to respond to call, what is the salary certificate? Why did I verify Iftikhar? How did the Iftikhar get his autonomy?
Miss Khiat, again, we go back to the same point that this doesn't go to your whistleblowing complaint. You've now changed your complaint, it appears.
No, it's not changing my complaint. It's just I'm denying the reasons that they say they terminated me for. And I get in the court eyes on the real reason. I'm just proving to you that these guys are lying with proofs. And I'm just getting the court attention to the real reason.
Right, but that, in my mind, taking me to this verification document, I'm just struggling to find out how. So you're saying that you were allowed to enter the chairman's office without authorization, and this document proves
there was no problem with me entering the chairman's room ever. There was no complaint ever. There was no warning ever. I entered the chairman's room several times, to be honest.
Okay, but
why?
So what goes to prove from this document that you were allowed to enter his office? That's what I'm not understanding. There's some.
I entered when there was people coming to his office to put new furniture. I enter his office like to open. The office boy sleeps there. The office boy sleeps there because the chairman never comes to office. He comes to office maybe one time in 2 months. There was also no restrictions. No one was telling us, no, it's not allowed, or you have to have an authorization to enter the chairman's office. There was no email, there was no policy, there was no one was telling us that it was forbidden.
Right, but Miss Khiat, we go back to the same problem, which is that you're saying your main complaint is that there was a fraud. Right?
It's a falsification, fraud. I don't know how it's like courtly.
Okay.
Like,
all right. This is your complaint.
Yeah, this is but I don't know how.
That's your complaint.
Like,
but
yeah.
Your complaint, and we've looked at it. We've looked at various things, etc. And I've explained on many occasions that for there to be something. Now, Mr. Dylan Malone has helpfully walked me through. I think it was pages 45, 46 of his bundle, which indicates the contract.
Sorry to interrupt. That was page 43.
43. Thank you, Mr. Dylan Malone, which shows the contract and the condition imposed at row 4 of that contract to say that Ms. Hijazi's salary would be uplifted upon passing probation and that she would be back paid.
Yeah, but no one was there. Again, no one was there to give her the offer letter. Even she was not there. How did she get it? If she get it through email, they should prove it.
In the alternative,
they can make 10 of it. They can make 10 of like this.
Ms. Khiat, this is what I'm trying to explain to you. Okay? This is what I'm trying to explain. Even if what you say is correct, and I don't buy it, to be honest with you, but even if what you say is correct and there has been something a little bit funny that's happened, it does not give rise and does not trigger the DRC operating law with respect to whistleblower protection.
But what is my situation? Why did I get forced to do this and then terminated for doing a good thing? How is it in the AFC courts? So if something like that happened to me, this is very, very, very dangerous.
Right.
Because I'm not their slave. Right?
Okay.
If they ask me to jump from the 32nd floor, I will not do it because the chairman said do so.
Now look, there is protection.
As a human being, how will I be protected from this?
Okay, let me explain that to you. So what would usually happen is if someone has been wrongfully terminated, and I've explained this before, if you've been wrongfully terminated without cause, without good reason, unlawfully terminated or wrongfully terminated, and there's no evidence to support this wrongful termination, then you would bring action under the employment law, okay? And then you might be able to claim certain things. In this situation, your case for whistleblowing, if this was something that involved a financial gain that the company would have gotten, for example, or some financial gain that the chairman would have received, or other gain that the chairman or a member of the company would have received, then yes, you would be completely protected by the operating law. Okay, but there is no gain in this situation. They have not gained anything. Even if they've done something wrong, they haven't gained anything from that. So your protection and what has happened in your situation is just from a very common sense perspective. It seems that there was tension, okay, the relationship between you and your employer wasn't working anymore, so they said, this is done, okay, and they have relied on certain things, and you know, there is merit to what you say. They've relied on certain things to prove that you were not performing to standard, and they've said this is why.
They don't have any proof.
They've got the proof of the attendance records, and you have not provided proof.
I told you, if there is any fairness in the AFC,
Ms. Khiat, I speak literally when I say, when you interrupt me, I cannot hear you. Okay, so please do not speak over me as I'm explaining what the position is of the court. You've asked a question and I'm answering your question. At the moment, it doesn't look like there is anything that you have provided. Yes, you provided the Snapchat shots, but to be brutally honest, just using a normal, and this is not something that Mr. Dylan Malone has raised, but when you look at the, you know, what is expected of a reasonable employee, taking Snapchat shots in a, you know, at the place of work is not something that really goes to prove that you're doing your work properly, for example, right? But in any event, you were terminated. Let's just say there was tension. You were terminated. You were paid out your benefits, and that's what was done. And if you had come back to say I was unlawfully terminated, and yes, I was paid out my benefits, but really I should be entitled to this much more money, that's a different claim. It's not a claim that you have made, and it's a different claim. But they have provided evidence of the fact that there is no fraud. They've also provided evidence of the fact that that you were not performing to standard. You have not provided evidence of your promotion letter, and I will grant you leave to provide further evidence after this hearing, before I hand down my decision, to provide the court with any type of demonstration that you were performing properly, perhaps, okay, and that your whistleblowing complaint does have feet and does have merit. I'm going to give you a very short period of time to provide those documents, because I've now explained to you what the court requires. Yes, but if those, right, but if those documents are not provided in the way that the court requires, or if those documents don't go to prove that your claim for whistleblowing has teeth, which at the moment it does not, then I will be granting immediate judgment to all three defendants. Now, I've already made up my mind that I'm granting immediate judgment in favor of the second and third defendants, because you have not in any way particularized your claim towards them, and that's Al Khair Capital Saudi Arabia and Khalid al-Mulhim. Okay, so, right, but you haven't already explained it. You haven't already explained it. I will give you a short...
in the submissions that I made.
Okay, Ms. Khiat, what are your submissions in respect of the second and third defendants?
The Khalid al-Mulhim is the way that ordered the fake salary certificate to be made. And given that Khalid al-Mulhim is sitting in Saudi Arabia, so I thought like both are involved in this. Because it's his secretary that got the salary certificate on.
Okay. Mr. Dylan Malone, Ms. Khiat, this is what I'm going to do for now. Yes, we've been in this hearing for...
Registrar,
Yes, Mr. Dillamiller.
I'm sorry, I just wanted to make, because I'm anticipating something which may be within your direction, and I
Yes.
think I just need to put it on the record.
Fantastic.
It is these allegations that that Mr. Zaman is lying. It's been made multiple times in the course of this hearing, and there's no sworn evidence from Ms. Khiat. I think this court must require sworn evidence if there is going to be an allegation of lying, and that is the minimum standard of evidence that would be required in terms of that it is not appropriate for even a lay litigant to multiply allege lying on oath on behalf of my client, by my client, when there is no sworn evidence by her before this court. And I think that's the minimum that must be required. If directions are being given, also the evidential deficit as a whole may as well be addressed, because there is no sworn evidence on Ms. Khiat's side, and we don't take a point on it, but it may as well be before the court.
Absolutely.
Just in relation to the, sorry, my last point, in relation to the employment law, employment remedies aspect, obviously my client must reserve its position on whether a remedy might exist at all.
Thank you, Mr. Dillamiller. So, Ms. Khiat, I absolutely agree with Mr. Dillamiller, and this brings me to what I'm going to, this brings me to my directions and what I require from you.
Yes.
So, you cannot tender evidence in court without it being under a affidavit or at the very least a witness statement. So, you've got to make an affidavit. I would prefer that the evidence is undercover of an affidavit, which you will then exhibit your evidence to. So the affidavit will tell your story of what's happened, and you will annex to the affidavit in the exact same way that Mr. Zaman has done so in his witness statement or affidavit, to say that these are the things that you wish to bring to the court's attention. So the things that you will be required to address are the fact that you were actually performing.
Yes.
You've got to show that you were performing.
Yes.
You've got to show that there was no issue prior to this complaint.
Okay.
And that there would be a real consequence for the company when this fraud is uncovered, in the event there actually is one, which I don't believe there is one. But you've got to provide some kind of proof that there is a consequence for the company.
I will try for any time to get the contract they provided to police. I will try that.
Right. Now, I'm going to give you 1 week to do that. Mr. Dillamiller, would you like to respond to...
Miss Nour, sorry, 1 week is not enough for me because I need to get some witness statements and the guys are not here yet. So my previous manager, Michelle Lane, is in England, and a lot of them are like not here yet.
Okay, so how much time do you need?
I'm sorry.
I need like 3 weeks to get all the evidence. And also I will try to get the police report, so I need to get a lawyer, to get the Dubai police station, try to get this report out of there. So I need a lot of time to work on it, and I'm working.
Right, but this is an immediate judgment application, Ms. Khiat. So the whole purpose of this exercise is just to give you a little bit of time to gather some things, just so that I am satisfied that I have heard you to the fullest extent. Mr. Dillamiller.
Yes, I think to be on the safe side, we should, if the registrar is so minded, we should include a right of reply. Maybe it won't be necessary. The suggestion that there are now going to be other witness statements coming in from other people, I don't believe is a fair outcome of the entire process. This is an immediate judgment application. We are at the end of an extensive hearing, and we have the mention at the death
How will
of
improve my performance?
another person who miraculously is going to back up Ms. Khiat's story when hasn't been done today. And I think we are bordering on the abuse of process. And in my respectful submission, it ought not to be allowed. Every accommodation is being allowed. If Ms. Khiat, in her own evidence, is able to substantiate to the degree required, then perhaps, as the case goes on, other witnesses will come in. But I think she should at the very least demonstrate to the court now and explain why any further witness statement, when there's been simply no mention of any other witness until now.
I mentioned it before. I mentioned that I have people really to witness, and I submitted that to the court.
Ms. Khiat, look, I'm going to indulge you, and I'm going to grant you, say, 3 weeks to provide your witness statement and no witness statements of anyone else.
But that's not fair, because my previous manager will say that I was good. The same that was in Iftikar's place, she will witness about my performance.
How long was your manager?
Yeah, also I have 2 managers ready to witness, 2 previous managers ready to witness for me. About my performance, about this accident also.
Mr. Dilla Malone, yes, I know that you'd want to object to that.
It's simply the first time that this has been mentioned, and I think that there must be a limit. If Ms. Khiat has letters from those people that she wishes to exhibit her statement, perhaps it can be done in that way. But I just simply, we cannot now, like some sort of black hole just at the end of the universe, open up an entire parallel universe. That is just not in my respectful submission, a fair direction to make in this particular application. Of course, we do not wish to shut down Ms. Khiat in any way as to bringing other supports of her position up to the record. But the notion that we should have an entire new case based on the evidence of witnesses who haven't yet even been identified is in my respectful submission, incorrect and ought not to be granted. And we can accommodate her. This court, in my respectful submission, can accommodate her to the fullest fairness and by allowing her to exhibit any support for her position that she can find.
Mr. Dilla Malone, the only issue that I have is that if Ms. Khiat was going to provide witness statements in support of her position, that's not really accruing costs on your client's part or anything like that. Obviously, you'd then have the right of reply should you wish to respond to those witness statements. But I do want to make it clear that she should have her day in court, and we can still resolve this through immediate judgment should the case require. So she can provide those witness statements. She's got 3 weeks to do so, not a day later, because this should be very efficiently dealt with, and the case should move on really after that. So 3 weeks, and the defendant obviously has reserved their right to respond to those, to your evidence in case they wish to do so. I doubt we'll need another hearing after that. I will deliver judgment shortly thereafter. So, Mr. Dilla Malone, how much time do you think you might need, or would you like to discuss it with the court after you've received? Okay.
Not at all, Registrar. Perhaps 10 days would be ample. 1 week would probably be sufficient, but I simply don't know, because I don't know what's coming. But I think 10 days to be on the safe side.
Okay, 10 days to be on the safe side. In the event Ms. Khiat decides to brief counsel or retains lawyers, then I'm going to give you a right to apply for an extension of time without having to make a Part 23 application, in case you require a little bit more time. So 3 weeks, Ms. Khiat. Yes. You've got until the 6th of July, 4 p.m. on the 6th of July, you must file and serve your evidence.
Yes. My evidence, which will be witness statements, my witness statements, and other managers' witness statements.
At this stage, I would prefer an affidavit, please. So I would like you to swear affidavit evidence.
What does that mean?
An affidavit is very similar to a witness statement, but it must be sworn before a registrar of the court or a legal practitioner who's not working on your case.
With a legal practitioner, right?
You can, yes, you may do that, or you may come into the court and have it sworn before a registrar.
But what if the witness is not here? He can do it and still like get it sworn or something like that in the country?
Yes, that's fine, or we might try and arrange a virtual swearing.
Right, okay.
Okay, but you must exhibit, I will be very clear on this point, you've got to exhibit evidence to your affidavit to set out your position entirely, supporting your claim, okay?
All right.
And rebutting the points raised by the defendants. And if you don't do that, then I will be granting immediate judgment in favour of the defendants and dismissing and striking out your claim in full. So please do provide that. You've got 3 weeks. The defendants then have 10 days thereafter with liberty to apply for an extension of time without the need to make a Part 23 application in case they wish to have a little bit more time to respond to your evidence and witness statement. I will then deal with the matter on the papers and deliver judgment shortly thereafter.
Okay.
Okay, so judgment is reserved.
Thank you very much, Registrar. Thank you.
Thank you very much. Thank you. Bye-bye.